So as far as the yellow brick road is concerned and, how a matter may look when we endeavor to undertake it as a prosecutor, unfortunately, it is not as simple and, picturesque as what we're looking right here from The Wizard of Oz. There could be many twists and turns and many different avenues and, arteries, if you will, that a matter can go. So let's look at this a little bit, more in depth, at least from sort of a high level overview. So if we're talking about part one of the POA, and this is all going to be most certainly part of the considerations of a prosecutor dealing with part one, this is a bit of a roadmap, if you will, of all the different avenues that a matter plausibly can take. So if you look at the very top of your screen, and as I just be mindful of the time here. So if you look at the very top of your screen, you can see that box that says pawn issued. So pawn just being another terminology used in the law enforcement world for provincial offenses notice, or a ticket, if you will. So once that pawn is issued or the proceeding is commenced, if you will, there's a number of things that can happen. So if you follow the line to the left and down, of course, the now would-be defendant can plead guilty. They can, do so quite simply by paying the set fine within 30 days. And done. Case over, so to speak. However, if you follow the line down the middle, what can happen is the person can elect what we more commonly refer to as option two. If it is indicative of a municipality that still has option two, so option one being plead guilty, pay the fine. Option two, as alluded to here in that box, it says ER. We're not talking about emergency room. No, we're talking about early resolution. So option two on the ticket. So if the person or the defendant does elect ER, of course, you follow the line down further to the left. If the person shows up on their scheduled early resolution date, the prosecutor would offer a resolution. Either the defendant is going to accept it and pay that fine, they plead guilty by their own free will in front of a justice of the peace, or if they don't accept it, they still have the right to take it to trial. So just because a defendant does not accept what the prosecutor is offering, an early resolution, or things go awry, the defendant does still, of course, have the right to take the matter to trial. Now, for that matter, if someone does not show up for their scheduled early resolution meeting, it is not just simply put over to trial. No, 9 sub 1 paragraph B of the POA says, if you're not showing up, you're still going to be deemed not to dispute. You elected for ER, you didn't show up, so guess what? We're pulling the plug. You're going to be convicted in absentia. Deemed not to dispute, you're still going to have to pay that set fine. Now, of course, if we sneak to the right, now we talk about the world of trial. And most certainly, if you follow the line down and to the left, if the defendant, does show up on their trial date, most certainly there's still the opportunity to have that resolutionary type discussion, prior to the docket commencing. If they show up early, everyone has the chance to check in, speak with the prosecutor. And for that matter, for municipalities that don't have this option two anymore, like York Region, for example, you'll be scheduled on a trial docket, and it's the inclination that you are going to be having this resolution discussion prior to the docket actually commencing with the prosecutor. But, irrespective of option two or not, there's still the opportunity, of course, for the defendant to speak with the prosecutor to discuss resolution prior to that trial docket starting. If the person, accepts the offering, then most certainly they're going to plead guilty and they'll pay the fine. If they reject it, of course, they can go to trial, and either they're going to be found guilty, have to pay whatever the actual sentencing is imposed by the justice of the peace. Of course, there's considerations for that, which we're going to get into, or for that matter, they may be found not guilty, or maybe the prosecutor even withdraws the matter for a whole host of varying reasons, which we will talk about. Now, needless to say, much like with the early resolution, if the person does not show up, they're deemed not to dispute. 9.1 of the POA, they'll have to pay that set fine, as long as, of course, the actual certificate of offense is proper on its face. The JP, of course, would look it over. So that is the world of part one of the POA, the roadmap, how things may go. Of course, all indicative of, your considerations as a prosecutor.